putting aside what the BIA thinks, why is this primarily legal? If I understand the question here, we have this word persecution, and the question is, how do we apply it to certain threats? And there's a legal rule that says, well, a threat can be persecution, but only if it's menacing enough to cause actual harm. And that's the legal rule. A threat can be persecution, but only if it's menacing enough to cause actual harm. Now, what's going to happen in this case is we're going to have to look at all this evidence, all these facts, and decide whether these threats were indeed that level of menacing. And that sounds like really weighing evidence to me. That sounds really factual.
So we disagree with that, Your Honor, and I think for two primary reasons. I think the persecution inquiry in itself, persecution, that's not a commonplace word like are two people acting as strangers like in U.S. Bank, or are people going to have a hardship like in Wilkinson. It's a term of art. It's the product of a treaty that this country has signed.
We're not though going straight from the word persecution. We in fact do have what U.S. Bank might have thought of as a auxiliary legal principle. And that auxiliary legal principle is it counts as persecution if the threat is sufficiently menacing to cause actual harm. Now, the question in this case doesn't actually have to do with whether that legal principle is right or wrong, should be changed or not. The question in this case is just, were these threats that level of menacing? And that's really factual.
So I think just one quibble with the question, Your Honor. We actually do dispute the propriety of that legal rule. It's not presently before the court. But when we were stuck.
But as this case comes to us, that legal rule is that legal rule.
To an extent.
Then I'm just sort of thinking. Then you're
Yeah.
saying we have all this masses of evidence of what the threats were and who made them, and how serious they were. I don't mean to belittle that. That's an important question, but it's a factual question.
We disagree with that, Your Honor, because—
I mean, it's a primarily factual question. You're obviously applying law to a set of facts, but what you're going to be doing in the way that the U.S. Bank opinion lays it out is really getting into the nitty-gritty of what the testimony is about what happened.
That's true to an extent, but I think the same thing is true in the fair use case. I mean, this court's opinion in Google versus Oracle was looking at the nature of declaring code. It got extremely in the weeds. Credit to Justice Breyer for doing that. But it's still involved, like any mixed question is going to involve a close look at the factual record. But I think what the inquiry in U.S. Bank calls for is asking, number one, is this standard something that people have of an ordinary common understanding of? I think the answer to that is no. And in addition to that, in applying this standard, is the stock judicial job just to say, oh, persecution, let's look at the facts and determine whether it's persecution. That's not what's happened in the lower courts, and the government doesn't dispute this. Lower courts have developed a slew of auxiliary legal principles related to threats, as Your Honor pointed out, but in a whole bunch of different areas: religious persecution, sexual violence. I could go on. And what U.S. Bank says is that when that is the case, you don't necessarily look at any given case that comes before the court and say, look, is this a boring case that's kind of run of the mill, or is this a case that raises some really interesting new issue? No, when courts are developing auxiliary legal principles, all decisions about that mixed question are reviewed de novo. We don't look at a fair use case and say, is this a boring one, or is this a really interesting one presenting novel issues? And I think that's the problem with the government's position. I do want to say one thing. To the government's credit, they've made, I think, a significant concession here that departs from the status quo in a lot of circuits, is that they have at least acknowledged that courts owe no deference to the BIA in interpreting the law, at least in some kind of purely legal sense, and in developing these auxiliary legal principles. And I think were the court to announce that and reaffirm it, with a megaphone, I think that would do a lot of good, and it would change how a lot of circuits address these cases. And we think in our case, it would warrant a remand to assess whether this requirement of—
Mr. Rosellini, do you think